in terms of apologies, I think we received
Recording
an
in
apology
progress.
from Honorable Badenhorst. Keshwan, I think, is that the only apology? Maybe just update me in the meeting if there are any other apologies.
Good afternoon, Chair. That was the only apology we received.
Okay. Okay, so on members, I'm just hoping that other members will join the platform. But just to confirm who's in the meeting at the moment, we have Honorable Smith, Honorable Bartlett, Honorable Mikolakis, Honorable Maleka, and Honorable Ndongeni currently in the meeting. Once again, welcome, honorable members. Just in terms of today's meeting, which I don't expect to take us terribly long, we have, Kishwan, I see you've taken off the agenda, but we have 3 agenda item points. The one is in relation to getting a briefing from the Department of Justice on the repeal of the Transkeian Penal Code, also tagged as a Section 75 bill. The second item, where in terms of our previous meeting where we were dealing with the Land Court bill, we were expecting to receive a briefing by the Parliamentary Legal Advisor on the tagging of the Land Court bill. And thereafter, based on last week's deliberations, as well as the briefing by the Parliamentary Legal Advisor, the committee would then continue deliberations on the submissions that were made on the Land Court bill. I think that being said, honorable members, welcome, and I'm going to, I see Honorable Dlamini is also on the platform. I'm going to then hand over to the Department of Justice. I'm not sure who's going to lead us with that presentation to brief us on the repeal of the Transkeian Penal Code bill.
Afternoon, Chair. My name is Tsietsi Sibelemecha. Just turning off on my camera just for a moment. I'm the Chief Director responsible for legislative development. With me, I've got a team of Ms. Alison Botha, who will take us through the briefing, and Mr. Hank Dupree and Makubela Mkuluvete will deal with the Land Court bill. If the chairperson allows, we may allow Ms. Botha to take us through the briefing. Thank you.
Thank you very much, Mr. Sibelemecha. Please continue, Ms. Botha. Is it Ms. Botha?
That's correct, Chair. Thank you to my Chief Director for the introduction, and good afternoon, Chair, and good afternoon, members. I'm also just switching on my camera for just a bit so you can see my face. And I'm going to get straight into the presentation, if I may. Here we go. So I will be leading you through a presentation on the repeal of the Transkeian Penal Code bill. But before I get into it, and just at the outset to sort of set the scene, as it were, I just want to give a brief background into the purpose of the bill and why it's necessary. So this bill deals with legislation that has essentially been left over by the apartheid regime. And the purpose of this bill is to erase that legislation from the books by repealing it. The apartheid government created 10 homelands, which contributed to the exclusion of Black people from the South African political system. And in the 1970s, the government then granted sham independence to 4 of those homelands. And the former Transkei was one of those 4 homelands, and it was granted independent status in 1976. The Transkei Penal Code was introduced in the former Transkei in 1983, and it is currently still in full force and effect in that area, despite the reincorporation of the former Republic of Transkei into South Africa. And it's in light of that historical context that this bill has been introduced to repeal the Transkeian Penal Code. This is just sort of the flow of the presentation, and the purpose is, of course, to brief the Select Committee on the bill. Just to get into the background behind this bill and later the Transkeian Penal Code itself. So when the code was enacted, the area known as the Republic of Transkei was legally in existence. The code codifies criminal law in the former Transkei, but despite the reincorporation of the former Transkei into South Africa 20 years ago, the code remains in full force and effect in the area formerly known as the Republic of Transkei, although that has ceased to exist. In the former Republic of Transkei, as a result of the application of the code, crimes are codified that are common law crimes in the rest of South Africa. The continued application of the code has created an untenable situation because criminal charges are brought in terms of the penal code in the former Transkei, but in terms of the common law and other statutes in the rest of the Republic. So the right to equality before the law is implicated, and that presumes the uniform application of the criminal law in the Republic and requires the state to ensure that there's a uniform system of criminal law and that there are no parallel laws that regulate the same subject matter in different parts of the country. The Transkei Penal Code can be traced back to an investigation in 1880 into the customary criminal law of Indigenous African communities, which culminated in the enactment of the Native Territories Penal Code, which is the predecessor of the Transkeian Penal Code. In 1976, the area formerly known as the Republic of Transkei became a so-called independent state, and the code was then enacted in 1983. And the purpose of the Transkeian Penal Code was to provide an amended, revised, and consolidated code of criminal law for the former Transkei. The code also replaced the common law in that territory. The interim constitution of 1993 reincorporated the TBVC states into the Republic of South Africa, but the code remained in force to allow the legislature time to harmonize laws in terms of Item 2, Schedule 6 to the Constitution. The Constitutional Court pointed out in SV Tunzi and another that the constitutional rationale for retaining the old order legislation, including the code, was limited and sought only to facilitate an orderly transition to a new constitutional order. So the application of the code resulted in legal uncertainty regarding whether the code superseded common law. In SV Solo, the court held that the code and not the common law was the applicable law in the area known as the Republic of Transkei. The South African Law Reform Commission reviewed the code and recommended that it be wholly repealed and that the common law rules, crimes, and offences that it abolished in the area formerly known as the Republic of Transkei be reinstated. The Law Reform Commission's preliminary research found that, with a few exceptions, the rules, offences, and defences contained in the Transkei Penal Code overlap with or have corresponding provisions in the common law or other statutes which are applicable in the rest of South Africa, resulting in legal pluralism and legal uncertainty. In addition, the Law Reform Commission found that a handful of the provisions in the code have been superseded by more recent legislation, thereby rendering the provisions of the code nugatory, redundant, or impliedly repealed. I just want to take us through a clause-by-clause discussion of the bill. The purpose of the bill is that it seeks to repeal and replace the Transkeian Penal Code of 1983 of the Republic of Transkei. The bill has no implications for other provinces except for the repeal of the code in the former Transkei, which falls within the geographical area of the province of the Eastern Cape. Clause 1 of the bill gives a singular definition, and that's of the Transkei Penal Code. Clause 2 repeals the code, and Clause 3 reinstates the common law in the area formerly known as the Republic of Transkei. Clause 4 is a transitional provision, and this has been inserted to cater for in-between cases. And by this, I mean instances where offences were committed under the code and before the commencement of the act. when this bill is enacted. It provides that where proceedings were instituted in terms of the code and not finalized before the act commences, those proceedings must be finalized in terms of the code. Also provides that where conduct would have been an offence in terms of the code and it occurred before the commencement of the act, then any investigation, prosecution, or legal proceedings in terms of that conduct can be finalized in terms of the code. In order to finalize these proceedings in terms of the code, the provisions of the code will continue to apply despite its repeal by the Act, but that is solely to cater for these in-between cases. As a saving clause, and the purpose of this clause is to ensure a lacuna or gap, area formerly known as the Republic of Transkeian, when the code is repealed by the Act. It does this firstly by providing certain things which the code for will be unaffected, and secondly by providing the powers and functions in terms of the code will be exercised by the holder of the corresponding powers and functions in terms of the corresponding law that's applicable in the rest of South Africa. And finally, it provides that when the code is repealed by the Act, that any reference in any law in operation in the former Transkei to the code should be construed as a reference to a law in operation in the rest of South Africa. Clause 6 is the final clause. It's the short title and commencement, and that the Act will take effect on a date fixed by the President by proclamation in the Gazette. As a final note, we have asked the NPA whether the penal code is still in use in the former Republic of Transkei, and the NPA has in fact confirmed that this is so. The Director of Public Prosecutions for the Eastern Cape, Advocate Barry Madolo, confirmed that almost 99% of all cases in the former Transkei are still dealt with under the Transkei Penal Code. But sections dealing with sexual offences were, however, repealed, and those are in line with national legislation. And the section that prescribed minimum sentences for assault GBH was also repealed, as well as including the section that required an accused person to outline the nature of his defence before the commencement of a trial. But it has been confirmed by the Director of Public Prosecutions for the Eastern Cape that indeed the penal code is still in use and in force in that area. I've come to the end of the presentation. Thank you.
Thank you very much, Ms. Puerta, for the presentation. I think, honourable members, that is the presentation from the department on the repeal of the Transkeian Penal Code Bill, which, as presented, is clearly in conflict with the current common criminal law that regulates the same subject matter in different parts of the country. And obviously, this repeal will remove the continued existence of apartheid-era legislation in the areas that were formerly known as the Republic of Transkei. Maybe, members, if you have any questions, but obviously what would come also to the fore is that given that Transkei was incorporated like 20 years ago into South Africa, and also the implications of this bill, why did the bill take so long to be introduced into Parliament? I think that would be one question from my side. And I don't know if members have any other question for now. If not, it's okay, then perhaps if you could respond to that for now. Thanks. Over to you, Ms. Puerta or Mr. Sibelimecha. If you could perhaps respond to that. Hello.
Thanks, Chair. I will defer to my Chief Director, but I know that work on this bill had started quite a while ago, and so I've picked up this bill quite recently. I'm a new recruit in our Chief Directorate, but I know that work on this bill has started quite a while ago as I go through the file. And so it has been something that our Chief Directorate and our department has been working on and refining and developing for a long time.
All right, okay, no, it's fine. I think Mr. Sibelimecha, do you have anything else to add?
Thank you, Chair.
Yeah.
Not necessarily, because as well, I joined the department in 2021, but as Ms. Botha indicated, when we joined, work was done, and also following up on the report by the South African Law Reform Commission. So we then had to continue because the officials who have been dealing with it have retired. So I wouldn't say much of the background before we joined and found the bill in the draft format. Thank you.
Okay, no, thank you very much for that. But obviously, I think this is also a matter we would elevate to your relevant principles. But I think we will in a future meeting do that. But that being said, honourable members, this is just the beginning of this process. It's our first briefing on the bill, and obviously we would put it out for public comment. And as a committee, we will still continue to deliberate further on the bill. I think, honourable members, if you don't have anything to say on this matter, I'm going to propose that we then move on to the next agenda item. I see Ms. Lutz, she's on the platform. The item being the brief that we expect from the Parliamentary Legal Advisor on the tagging of the Land Court Bill as a Section 75 bill. I think the department did touch on it as well in our previous engagement, but that being said, I will request our legal advisor to make that presentation. But also, I just want to remind the department as well, there was one matter in our previous meeting that you said you would also come back to us in terms of you needed to maybe reference and or refer to what was being asked with regard to the A list and clause 29. And I'm hoping that you're also able to, after we get the briefing by the legal advisor, if you have a comment to make on that, please do that. And I think thereafter, honourable members, we can then engage. Over to you, Ms. Lutz.
Thank you, Chair. Good afternoon, Chair. Good afternoon, members. Chair, as I have it, the opinion has been circulated. So with your permission, Chair, I'm going to highlight the crucial aspects to give the committee an indication of why the bill is a Section 75, although there was a public submission that indicated or argued that it should be a 76. We respectfully disagree. The bill was initially introduced as a 75 by the Minister of Correctional Services and subsequently also so tagged by the JTM. The main reason for this is that the bill deals with the setting up of a judicial structure in streamlining the legislation, dealing with the jurisdiction, where do certain claims go. It doesn't deal with the substance of a claim. It doesn't deal with what is a land claim or how those should be argued or what the elements of such a claim is. It specifically just sets up the structures within which such claims can more efficiently be processed. So if I can just highlight to the committee, for that reason, the bill establishes and sets out the jurisdictions of the Land Court and the Land Court of Appeal. It allows for certain appointments of judicial officers. It allows for the appointment of assessors, aligns the bill with the Superior Courts Act, provides for the rules, allows for certain interventions of applications and self-representation, and then also when it comes to the rules of securing a witness and evidence. So as members can see, these are all very much procedural aspects that are fleshed out with every court that is established. It's not something that's specific, just a land court issue. These are functions and rules that need to be put in place for a court to be functional. So it's very much structural, procedural, administrative, and nothing in the bill looks at a land court in an issue the issues in a substantial matter. So if I can just go down to what the public submission argued, that provinces have a clear constitutional interest in land reform. The submitters said that agriculture and housing and regional planning and development, urban and rural development are functional areas within Schedule 4, and he highlighted planning is a functional area and exclusive provincial legislative competence in Schedule 5. He's not wrong that those are the issues in those schedules, but he is misplaced in arguing that those are issues that fall within a substantial level, falls within the ambit of this bill. This bill does not deal with those issues. This bill puts in place a structure of a court who will eventually deal with land claims and land reform issues. So there's no Section 25 considerations of the Constitution here when it comes to land reform either. He says the bill brings substantive challenges to the legislative environment surrounding land reform. No, the bill actually tries to eliminate procedural and administrative challenges. There is also the argument being made that because the bill has a schedule that amends certain other legislations, which the submitter listed as the Community Property Associations Act, for example, because they were processed as Section 76 bills, it's argued that this bill should also be a Section 76. And that argument is also misunderstanding the way our processes work. Just because the original Principal Act was initially a 76 does not mean that any amendments thereafter is also automatically a 76. It depends on the actual content of a specific amendment. So we look at that amendment and what that amendment tries to do. And in the schedule of this Land Court Bill Act, the schedule does certain consequential amendments that still aligns with the main purpose of this bill, which is to put in place those structures to streamline jurisdictional issues, to allow for easier access to the land court. So from our perspective, Chair, this is still a Section 75. We understand that people, when they hear land courts, land issues and land reform issues are very close to the heart of our nation, but this bill does not deal with any substantive issue. So for that reason, we still hold the position that it should be a 75. Thank you, Chair.
Thank you very much, Ms. Lutz, for that presentation. And that presentation is actually also in line with the comments that we received from the public with regard to the tagging of the bill. Our members, okay, before I open it up for if you have any question for clarity or comment you would like to make, I want to go back then to Mr. Mukulubete and the team from the department that's dealing with this bill, just to deal with the other matter that you could not respond to in our last meeting with regard to clause 29. Mr. Mukulubete, are you able to do that now?
Yes, thank you, Chair, and good afternoon to you and the honorable members. Yes, Chair, we went back to our documents to have a look at what the Chair was raising in relation to that clause. And I have to apologize, Chair, to the effect that it was a mistake that that provision, the provision that we have contained in the A list that's served before the portfolio committee did not find its way properly and appropriately into the bill that served before this committee. As a result, Chair, and when we are given that opportunity, we are going to address that issue. We are reinstating or incorporating that very provision that didn't find its way into the bill. And then we will be able to address the committee on that aspect further, because it also touches upon one of the aspects that we addressed the committee on last week, that we are going to effect amendments on. So that clause is essentially going to be amended further on top of what the chair has highlighted to us. And once again, I do apologize for the omission. Thank you, Chair.
Thank you very much, Mr. Mokulubete. Our members, I'm going to then just open it up to yourselves as well, based on the presentation that was made with regard to the taking of the bill, as well as the presentations or the departmental responses that we received in our last meeting, where members felt they might, if they had any other issue they would want to raise, that we also allow that to happen. So if you have anything else that you would want to raise with regard to the presentations that were made last week, please feel free to do so. If you do have, if you don't, it's okay, because I think some members were covered to some extent in the last meeting. So if is there any member that wants to raise any matter or raise an issue for more clarity, please do so, or give me an indication that you would like to do so. Okay, I don't see any hands being raised, but anyway, honourable members, we're still processing the ball. I think in the last meeting as well, what I had said to the legal teams was that based on the discussion, that they should also go ahead and look into what the proposed amendments actually amount to in terms of this bill. And I think they did come up with a working document, which I'm sure members haven't had time, neither had I time to also look into that document. But I would want to propose to both the Secretariat of the Committee, Gershwin, and to the legal team to ensure that you be quite thorough, even based on what was said with regard to clause 29, in terms of what the proposals might be, and then in the next meeting, you would then present it to members for further discussion. If that is okay, then honourable members. Okay, Honourable Mikolakis, I see your hand is up. Honourable Mikolakis.
Thank you, Chairperson. Good afternoon to you and everyone else on the call. Chairperson, yes, just on that topic, I would also just request that we keep in mind that some of those amendments will have to also go to our caucuses, at least in the procedure that we follow. I suspect some of the other parties are the same, but that we will just need ample time from our side in order to get a mandate from our caucuses to vote. So when we look at timeframes for the adoption of the different clauses, that we just keep that in mind so that we can do a proper job from our side as well. Thank you, Chair.
It's fine. Thanks, Honourable Mikolakis. Duly noted. I think that being said, I would also want the legal teams to be quite thorough with what needs to happen, so that when they do produce the relevant documentation, they should liaise with Gershwin, and then he would then forward it to members of the committee. I know you have some working document, but I want to propose our members to just wait for a final product, which we hope, well, I'm hoping maybe by the end of this week we could get it from the teams and then perhaps send it through to honourable members. I think that being said, honourable members, we've come then to the end of the agenda items. Let me once again thank you very much for your attendance and your contributions, and to thank the legal teams as well, because I see the document that just looking briefly at the document that was produced, it looked quite detailed, and yeah, I guess that we'll discuss it further then in our our next meeting. I don't think next week, Wednesday, honourable members, we'll have the time for a meeting because of the program of the NCLP. So we're probably going to be looking at when we come back from recess. That being said, thank you very much, honourable members. This meeting is adjourned.
Thank you, Chair.
Thank you, Chair. Bye.